Hawk Tuah Girl Hayley Welch is threatening to sue people who are capitalizing on that famous viral phrase. Will she succeed? Well, let's see. I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to talk about trademarks and copyrights. If you have trademark or copyright law questions, drop them into the comments below. I'll answer them on a future live. So in a video published last week, Hawk Tuah Girl Hayley Welch threatened to sue everybody who is making money. She's really pissed off. She says that she's not making the money. She's threatening to sue everybody who's making money off of the Hawk Tuah phrase. And she says that her manager and her lawyer are going to be coming after them. Very interesting. Let's talk about why. She doesn't really have any rights that she can enforce at this point. I went and looked at the trademark record, and it seems that there are a number of people, at least 22 people, who have filed applications for use of the Hawk Tuah trademark on various goods and services, including things like clothing, toilet seat covers, 3-in-1 shampoo, conditioner, body wash, cleaning supplies, beer, energy drinks, baby clothes, super weird that one, teeth whitening, and personal lubricants. So she is behind almost all of those people for all of those trademark applications. She filed her application on July 2nd. Now, the video went viral on July 23rd, and she filed her application claiming use of the Hawk Tuah trademark back to June 9th. Now, I'm not sure how you get back to June 9th unless that was the day the video was recorded, and so her attorney, who I don't think is a trademark attorney, may be alleging that that was the first date of the trademark use in commerce. But in the trademark office, in commerce means something more than just uttering a phrase in a video. For use of the goods and use of the Hawk Tuah mark on the goods and services, she's going to have to show that she was selling those goods and services with the mark applied. I don't think she's going to be able to prove that, especially since the video didn't go viral until June 23rd. She applied for her trademark for comedy services. Yeah, she's going to be a comedy. She's applied for entertainment services and for clothing. I don't think that she's going to be able to prove use on clothing as of June 9th, because she didn't start selling them until after the video went viral, and it went viral on June 23rd. The math isn't mathing there. There is one guy, his name is Richard OReilly, he's in Indiana. He has gone all ham on the trademark applications. He filed 10 separate trademark applications all by himself. Who's going to tell him that he could have done all of this with just one trademark application? But that's okay. He went all ham, and he's filed a bunch of trademark applications for a lot of the funny stuff that I mentioned earlier, including the baby clothes and the toilet seat covers and the 3-in-1 body wash. Now, he filed his application for clothing also on July 2nd, but he filed it before Hayley Welch did. Another interesting little tidbit, she is using an LLC called 16 Minutes. I suppose that refers to the 15 minutes of fame that people get. Sorry, you only get 15, not 16. So that's kind of cute. I like the humor in that. So it's interesting to note that at this point, Hayley Welch's trademark application, again, filed under the LLC 16 Minutes, she's behind 8 other people who filed before her for clothing and other clothing items like boxer shorts and things like that. So she doesn't actually have, unless she can somehow prove, which is very doubtful, that she was selling clothing before these people applied, right? Because the rule is that if you're filing based on your intent to use, when you file, you get your priority date. If you're filing based on use, you can claim use back to the day you actually started selling. But you're going to have to be able to prove that with, actual proof if somebody challenges your trademark application. And I think a lot of these people will, because I don't think she's going to be able to prove that as of June 9th, she had use of the trademark on anything, much less the clothing, because the clothing, she wouldn't have had any reason to put that up for sale until the video went viral, and it went viral on June 23rd. As for any copyright rights, she doesn't have any copyright rights either, because here in the United States, words and short phrases are not capable of copyright protection because they lack sufficient creativity to reach that threshold of being registerable at the Copyright Office. So I'm afraid she's out of luck. If you know anyone who's being threatened by her or her attorneys, please show them this video, because I think it's worth noting that they most likely applied before she did. They most likely started selling before she did. And so she doesn't have any right to now become a trademark bully just because she's decided that she is owed some kind of rights to the phrase that she uttered when she was, drunk and silly and being filmed on the street. The only cause of action that she might have is if someone else is using her name or likeness in order to market products. So if somebody took her face and stuck it on a product and was selling that, she might have a cause of action for that. But as for just trademark rights to the phrase Hawk Tuah or copyright rights to the phrase Hawk Tuah, she doesn't have any rights that she can enforce at this point. I'm Angela Langlotz. I go live to talk about trademark and copyright law. I love these case studies because they are very entertaining and they bring trademarks and copyrights down to real life where people can really apply and understand them. If you have trademark or copyright law questions, drop them into the comments below. I'll answer them on a future live and tag you so that you know I responded.